a general rule, as we know, in tort or in general, a man is liable only for his own act, but there are certain circumstances or there are certain situations in which a person or a man is liable for the wrong committed by others. In master and servant case, what happens? Master appoints or employs a servant to do a certain job or work. If while doing that work, servant commits any wrong, then for that wrong, if someone else or the third party suffers, then due to that particular wrong committed by the servant, master will be held liable. The most common instance is the liability of the master for the wrong committed by his servant, as I have already discussed. The plaintiff can sue the actual wrongdoer himself. The plaintiff, the suffering party, the third party who has been harmed or who has suffered loss. That person can sue the actual wrongdoer. That is, if the servant has committed any wrongful act or has done any wrongful act, and due to that wrongful act, another party has suffered any loss or the plaintiff has suffered any loss or harm or injury, then the plaintiff can sue the servant, be he a servant or agent, as well as his principal. Plaintiff can sue both servant as well as principal or the employer who has employed the servant to do that particular act or job. So now we will discuss the liability arising out of special relationship. Vicarious liability may arise where the doer of the act and the person sought to held liable therefore are related to each other as master and servant, that I have already discussed now. If servant has done something wrong, then master will be held liable, or the servant can also be held liable. Next, owner and independent contractor. Next, principal and agent, company and its director, firm and its partners, husband and wife, guardian and ward or father